Thank you, Mr. Chair. I'll be brief. This deals entirely with the strict liability statute related to these types of remediations and what happens after. Strict liability means the fact that an event occurred is sufficient enough to prove the culpability, and a plaintiff does not need to prove bad faith, negligence, intentional conduct, all the myriad of different situations that could arise. It happened. There's your proof, right? So claims can still be brought under negligence, wrongful death, trespass, Resource Conservation and Recovery Act, Federal Comprehensive Environmental Response Compensation and Liability Act, Public Nuisances, Florida Deceptive and Unfair Trade Practices. There's a myriad of other options that are there. So this bill's obviously come a long way. This bill started off with prevailing party attorney's fees. We removed that after hearing concern. This bill obviously just removed another significantly large section in it that sought what I think is meritorious, but there was enough concern to where maybe we needed to reconsider that going forward, and we just took care of that too. This part of the bill, I believe, is very sound because we're going back to how things, and I know this is going to sound very contradictory, but my understanding and read of this bill is that prior to 2019, we were not dealing with, so 1983 to 2019, we were not dealing with personal injury claims. It was only to property, not personal injury. After 2019, so very recently, 5 years ago, that, and I think it's the cases Lupo v. Simon or Simon v. Lupo, that's where the Supreme Court said this statute may be overly broad, and that's something the legislature then needs to address. And that's how we got to where we are today. So really, what we're doing is doing what the Supreme Court basically said we needed to do and clarify this and go back to where we were and what was obviously intended. And so that's why I just want to make sure that nobody misunderstands the intent of bringing this forward, and that there's a significant erosion, to use the phrase, maybe a bad word, but to use the phrase of something that's existed that long. That's not how I read this, and that's not how I've interpreted it. So I ask for your favorable support. Obviously, I've shown a deep commitment to continuing to work on this bill and happy to have those discussions. I know some individuals from the fishery industry have spoke on this, and I'm happy to meet with them. Haven't had a chance to do that yet, but I would love to talk through some of their concerns and issues too. I believe Deepwater Horizon a lot of the settlement there was brought forth by the Attorney General under 20-something different counts, and obviously millions upon millions of dollars were collected. And so what this bill did or is doing would not impact what happened in Deepwater Horizon at all. And I want to verify that, but that's my understanding of that. And I think it's pretty clear. So this is a good faith bill. We're trying to do the right thing. We're trying to make sure that we're encouraging remediation when a permit, when an authorization was given, that somebody doesn't have to look behind their back 20 years from now and wonder if someday something's going to come a-knocking because of what they remediated in accordance with the law 20 years ago. That's the entire purpose. For that reason, I ask for your favorable support.
To close on your bill, Michelle, please call the roll on CS for Senate Bill 738.